Hi, everybody. My name is Tia May, and I am here to discuss my case presentation of Maverick Recording Company versus Steve Harper. The plaintiffs in this case are Maverick Recording Company, UMG Recordings Incorporated, Arista Records LLC, Warner Brothers Records Incorporated, and Sony BMG Music Entertainment. The defendant is Steve Harper. So the plaintiffs are the exclusive copyright owners of these copyrighted recordings, we'll call them. Obviously, they're songs. But they claim that Harper reproduced this copyrighted material without permission or consent using an online distribution platform. You may have heard of it. It's called peer-to-peer file sharing platform. And this was part of a big, what they call drift net litigation technique by all of these big corporations. Basically, they decided to sue over 18,000 individuals for copyright infringement because they were on this file sharing platform, sharing files with each other that they really had no ownership of. So the main issues were, like I said, the plaintiffs believe that the defendant had violated their exclusive ownership rights under the copyright law because he reproduced and distributed these copyrighted recordings. The defendant used many counterclaims, well, a couple different counterclaims, and his main defense was that the lawsuit is, the DriftNet lawsuit. It's over 18,000 individuals who are being what the defendant calls dragged into court, where they may or may not have understood the implications of what they were actually doing. Some people didn't know what they were installing on their computer. Some people didn't know that it was wrong. But his two counterclaims that the defendant entered are declaratory judgment of non-infringement and copyright misuse, which I found interesting. Again, the copyright law gives the owner exclusive permission over reproducing their own material. And there were 18,000 citizens put in court for the use of this software. And just to define the copyright misuse counterclaim, with copyright misuse, basically you're saying that the plaintiff violated some kind of antitrust laws or public policy or abused the copyright laws in some way. As we get into the legal analysis, the defendant believes he did not violate the plaintiff's exclusive rights. Because of a copyright infringement claim, it requires proof of ownership and actionable copying. And the defendant was saying that based on the exact same things that they were saying, based on the fact that he was on the P2P website and he downloaded and distributed that music, that wasn't copyright infringement. So it was just a mirror image of the plaintiff's defense. There were no different facts, no alternative facts brought to the case. It was all based on the same thing. So what that meant, to my understanding, was that if the plaintiffs moved to voluntarily dismiss this motion, they would actually dismiss their entire case, which is on the copyright infringement claim. So that was a tactic from the defense to anticipate, seeking dismissal, voluntary dismissal. So counterclaim 2 only holds up if the plaintiffs, again, are found culpable in violating copyright laws. But the issue here is that this counterclaim is usually a defense. It has only been used in the court of law as a defense. So the defendant claims the plaintiffs are violating antitrust laws and public policy, which would forfeit their exclusive rights under the copyright law. So this brings us to our case that brings legal precedence, which is the Lasercomb America Incorporated versus Reynolds case. In this case, the plaintiffs, there's an original case and then there's an appeal. The plaintiffs were Lasercomb America Incorporated, and then the defendants are Larry Holiday and Job Reynolds, who are the owners of Holiday Steel, which is a steel company, which is a rival to Lasercomb America. So they're both steel companies that they score paper for creating boxes. So they kind of both do the same thing. And around the time 2007, when this case was tried, there was a lot of competition going on between them because they wanted to, mass produce at the same time. There ended up being a discrepancy where there was software sent from Lasercomb America to Holiday Steel. And they sold the software to them. They, basically told you, here, you can use it. And they sold it to them. After they sold it, Lasercomb America came back, and once they saw that the Holiday Steel company was actually reproducing this software, making different versions, basically doing what they weren't authorized to do with it, they actually didn't have a copyright registered. So they ran and registered their copyright, and as soon as that was registered, they filed an action suit against Reynolds. So that's the controversial part of it, is that they sold the copies of the software to the defendant's company. But again, the defendants were not authorized to reproduce this. They did not deny reproducing the software. They basically said, yeah, we reproduced it, but you gave it to us. So in the original case in the district court, the plaintiffs were awarded $105,000 for this case. And when it was actually taken to appellate court and the case was taken on and retried, that's when the defense of copyright misuse came out. And although the copyright misuse defense was rejected, this was pretty influential in making the copyright misuse case, because in this case, the defendant was actually able to prove that Lasercomb America was culpable in helping them copyright their own stuff. Because they did the transaction without copyright, actually a registered copyright, it makes it harder to take action against the defendants. So the plaintiffs, again, we're back to our regular case. The plaintiffs say that there is no support for this copyright misuse claim because, again, you have to actually violate the laws and somehow. They didn't go back. They didn't try and backtrack and register. All of their stuff was registered already. So the defendant, they said, and also this is used in defense. So the defendant tries to justify his counterclaim again with an example. And he used an example through electronic data where the court allowed copyright misuse to avoid responsibility for something that had happened. But the example ended up, basically proving that he was looking to find affirmative relief through the copyright misuse claim, not defending, he's not creating a defense. He's saying I should be relieved of this because of copyright misuse. So, for the final ruling, the court grants the plaintiff's motion to dismiss the defendant's first counterclaim, which was the declaratory judgment of non-infringement. And they dismissed that one. And then they also dismissed the defendant's second counterclaim for copyright misuse. And then obviously we used our case of legal precedents to explain that. And then lastly, they granted and dismissed the defendant's counterclaim, which means that the plaintiffs won in this situation. So that is the end of the Maverick Recording Company versus Harper case. And now I would like to go into my open discussion questions. So my first question, do you think the drift net approach used by the plaintiffs, where they sued over 18,000 U.S. citizens for being on the P2P platform and using and violating their copyright laws, do you think that this was a fair way to solve the copyright issues? Remember, this is back in 2007, before the copyright issues were running rampant, when the use of the internet platform picked up. Do you think that this was fair? Do you think that they should have sued the Americans? I guess I'll give my opinion. I personally think that there's a different way they could have went about it. rather than just suing individual Americans. But I get the point that they were trying to make. And then my next question, in the secondary case, what do you think about the timing of Lasercomb registering their copyright and filing action against Holiday Steel? In my opinion, if you are going to sell something, say, hey, I would like $2,000 for you to use this software program, you should already kind of know that you need your stuff copyrighted. Anytime you give something away, you're kind of asking for it to be reproduced. And that's what happened. It was reproduced. So, what is your opinion on this? And these are my references. Thank you for listening.